Hi, everybody. I'm Shauna Fleischbein with Castle Group. If you're not familiar, I think most people joining with us at this point are familiar with Castle, but if you're not familiar with Castle, we're a full property management firm. If I can get my words out this morning. Um, Full service property management firm servicing all of Florida, and we specialize in full-time on-site management of large scale homeowner association and condominiums. And today I'm joined by my guests here, Adam and Monique from Raven Parker Gurley. So we appreciate you guys being with us this morning. And I'll let you guys introduce yourself and the firm as well.
Thank you for
Great.
having
Take
us,
it away.
Shauna. Adam, you want to go ahead and introduce the firm and kick us off?
Yeah, absolutely. Good morning, everybody. Thanks very much for joining us again. My name's Adam Gurley. Thanks to Shauna and Castle again for inviting us to join this morning and present to you all. I am a partner with Raven Parker Gurley. The primary focus of my practice, we represent community associations. That is the bulk of our practice outside of litigation. And I handle the litigation and enforcement for the firm. So the topic for this morning is right on point and right in my wheelhouse for what I've been doing for the last decade or so with the firm. Monique Parker, my law partner, does a lot of litigation, enforcement, and corporate governance. And so we are here to talk to you this morning about litigation, but really what leads to litigation, the buildup to litigation. We want to take you, and when we've taught this course in the past, we found that the most beneficial way to present the course is, okay, let's start with an actual violation that some of our owners or managers have experienced. And let's go from the initial notice all the way through to, the lawsuit and its conclusion and talk about what that process looks like and what the steps look like. So that's the plan for today. Monique, did you want to add anything to that?
No, just pick a good violation so that we don't get screamed at after the webinar.
Yeah, last time I picked a dog violation and I had some owners come up to me who were very upset. They love dogs. I'm like, me too. It's just a violation in some communities. I think let's do nuisance conduct today. I think a lot
Okay,
of
I
folks
like
that are
that.
dealing with
That's,
that. Is
that's
that
what
a good one,
everybody.
Shauna?
Yeah, perfect. So what I'm going to do is I'm going to stop sharing so Adam can share the presentation. And just a reminder to everybody on today, my colleague Laura and I will send out emails to everybody who's either joined or who even registered, wasn't able to join or stay on. It'll have a link to the video and it will also have a link to the presentation today. Any managers who are on, if you did not submit your CAM number to us, make sure you do that following, because this one is for credit for CAMs, correct?
It is correct.
Receive credit. Okay, perfect. And then, as Laura mentioned earlier, you can submit questions throughout, and we will get to those throughout the presentation. Just please try to keep them on topic and not too crazy specific to your community, just so it's good for everybody. So there we go. Adam, you're good. So I'm going to hand it over to you to take over.
All right, perfect. Thank you again, Shauna. All right, so litigation and enforcement. And before we dive into our specific violation for the morning, the harassing board member, or not board member, sometimes board member, owner, the nuisance conduct, the nuisance resident, we'll start with the more overarching point of the law and something for board members to understand. And that is the board's fiduciary duty to enforce the governing documents. So oftentimes we'll see new board members join the board, or managers will deal with a board who says, look, we really don't like this particular covenant. It says no basketball hoops can be stored overnight. We don't like that particular provision. This new board doesn't want to enforce it. And that's not something that's within the board's discretion if that's within your governing documents. You have to enforce your covenants, your restrictions, and you have to do that uniformly across all owners and residents. So if you have an owner or a resident who continues to violate the governing documents and you go through a lot of the process that we'll talk about here this morning, you don't have the option in most cases, or at least some cases, to just wave the white flag and say, look, they've called our bluff. We've tried to find them. They've not come into compliance. We really don't want to spend the money on a lawsuit. So we're just going to end this now. And unfortunately, they've put your back up against the wall. You really don't have the option to forego a lawsuit or forego the next step, whatever that may be. And again, we'll go through that this morning because you have a legal obligation as a member of the board to enforce your documents and to see it all the way through to make sure that owner or that resident comes into compliance. So that's sort of the big picture when you step into your role as a board member or as a manager to counsel your boards, that is indeed their obligation. So again, we'll start with a particular violation. So let's start with the nuisance conduct, and that can be harassing board members, it can be harassing management, it can be, loud music and parties overnight, any of the above. And we're seeing, it seems like, more and more of that of late in particular. So how do we go about addressing that? What's the pre-suit process? What's the litigation process if we can't resolve it with some of the pre-suit measures that we'll talk about? Well, the first obligation for the association is to provide the offending owner or resident notice and an opportunity to cure, and that's written notice. So that's the first shot over the bow, if you will. That's the, look, you're in violation as follows. Describe the violation. You have loud music playing in your condo all night. You're harassing management, whatever it is. You have 10, 14, whatever reasonable time period to knock it off, basically. And if you don't, then further legal action will commence. But the law requires you to, again, provide at least one initial notice and provide them the opportunity to come into compliance on their own before you proceed with fines or any of the other legal action that we'll talk about. Now, you can give them notice of your intent to fine, or the initial notice of intent to fine, or notice that you intend to suspend their use rights in that initial letter if you so choose. But Monique, how do we feel about fines and suspension of use rights as a beneficial remedy in general?
Well, how do we feel about them? Not great anymore, and I'll go into why. As it relates to condominiums, we'll start there because the Condominium Act hasn't changed much. For the most part, condominiums have the authority to impose fines. You have to give the due process, as Adam said. Then there's a very specific notice of the proposed fine that you need to send that gives the owner 14 days notice of a hearing that's going to be held. And the hearing has to be held before an impartial fining committee. And that impartial committee can't have any directors, any family members of directors, anybody living with directors. It has to be truly impartial. And that 14-day notice, we get a lot of questions about that. Well, do we have to give them 14 days to cure? What if it's a nuisance behavior? Don't we want them to cure right away? Yes, but to keep life simple for you and for your management agent, if they are the ones that are issuing these fines, we generally recommend that the cure period is 14 days along with the committee notice period, because it makes it a lot easier. So 14 days before the hearing, you have to give that notice. Then the fining committee meets and they can either uphold or waive the fine, depending on the information provided at the hearing. If they uphold the fine, then the notice must go to the owner indicating that the fine was upheld, and payment is due 5 days after notice of the fine is given to the owner. That's been in the statute for quite some time now, and it really hasn't changed. So most of you, especially if you're CAMs, probably have that dialed in pretty well.
Go ahead.
No, I was gonna say the problem with fines in a condo context is, let's say you do everything perfectly. It's not very complicated for condominiums under the statute. You've dotted all the I's and crossed all the T's and everything's great. Now you have a fine, it's accumulated up to the maximum amount of $1,000. What if they don't pay it? So what? There's not really a whole lot you can do. You would still have to take them to court to enforce it. And do you really want to take somebody to court and litigate, which we'll talk about more, the costs associated with that and the different venues for $1,000? Probably not. So you're still kind of left back at square one. You cannot lien for a fine in a condominium. So that doesn't get you very far. So you might be thinking, okay, well, if it's an HOA, we can lien for our fines. So doesn't that make it easier? Well, maybe, maybe not. The problem is the legislature, in its infinite wisdom, substantially modified the fining procedures in the statute for HOAs. And in doing so, they have left some serious ambiguities in there and made it a little bit more complicated than it used to be. So to begin, HOAs still have the authority to impose fines for violations of the governing documents, including nuisances. And actually, pause there for a minute. Make sure your documents are clear about nuisances. We do every now and then see that nuisance provisions really only address sound. We like to expand those to, address all nuisances. So first, you got to make sure that it is a violation. But assuming it is, then an HOA can impose a fine if you go through the proper steps. The fine can exceed $1,000 if your governing documents allow fines to exceed $1,000, and it can become a lien against a parcel as long as it has reached the $1,000 threshold. Anything less than $1,000 cannot be a lien against a parcel. So you would think, okay, great, if we can lien for it, then there's some teeth to that. There's some enforcement ability. The problem are the procedures. So let's talk about those. You still have to give the initial notice, like Adam was talking about, a due process, a friendly warning. You can call it what you like. So that first notice of the violation goes out. Then you have the notice of your intent to fine or suspend use rights. And by the way, if you're suspending use rights for violations, all these same procedures apply. So you can kind of follow along that way. But you have to give that same notice with 14 days prior to the committee hearing that's going to take place. So again, I always recommend combining it whenever possible, 14 days opportunity to cure and 14 days minimum prior to the hearing at which the committee is going to decide if the fine is going to be upheld. The hearing has to be held within 90 days after issuance of that notice. Typically, that shouldn't be a problem, but some communities really have a difficult time getting that fining committee together. Some people just don't want to volunteer. So if you're having trouble getting people to volunteer and you can't hold the hearing within 90 days, then it's going to fail right there. So let's assume that the committee assembles and you have the committee hearing. Well, that's great. The committee can uphold or reject the fine, but if it's upheld, then we get to the complicated issue under the statute. A notice must go to the owner stating that the fine was upheld, stating the timeline to pay, and stating how the violation may be cured and when. There's the problem. It doesn't really say how much additional time you need to give the owner to cure the violation from the time that the committee meets. There's also the two words "if applicable" in the statute. And there's a lot of disagreement among attorneys practicing in this area whether or not that "if applicable" means you have to give another cure period or it's optional. It's just very, very ambiguous. So I'm going to actually read this to you. It basically says, within 7 days after the hearing, the committee shall provide written notice to the parcel owner at his or her designated mailing or email address in the official records of the association. There's a little bit more about that. And the notice must include the committee's findings related to the violation. So that's the first thing you have to include. The applicable fines or suspensions that were approved or rejected. So even if the fine is rejected, you still need to give this notice. And here's the part: how the parcel owner or any occupant, licensee, or invitee of the parcel owner may cure the violation if applicable, or fulfill a suspension, or the date by which a fine must be paid. So if this cure thing is in there, there's just really no consensus on how long you have to give them. Should it be 30 days? Should it be less? It's seriously unclear. Then the statute goes on to say if it's cured before the violation's cured before the hearing, then the suspension or fine cannot be imposed. So there's number one. If they cure it before the hearing, so you give that initial 14 days and then you set the hearing, let's say the hearing 60 days later, if they cure any time during that period, the fine cannot be imposed. If they cure in the manner specified by the notice provided by the fining committee, then the fine cannot be imposed, or the suspension. So we get back to that. What does the committee need to decide as far as that cure period? If the violation is not cured before the hearing or within the time set by the committee, then it can be imposed, and the committee needs to notify the owner of the date by which the fine must be paid, which cannot be 30 days less than the date that the notice is delivered to the owner. So there we have another problem. You have to know when the date is delivered. So I can't talk today either, Shauna. We need to make sure that we're sending those letters by certified mail, and hopefully that they're going to be signed for so that you actually have the date of delivery. What if they reject it? I suppose we can still say that it was delivered on that date. Just because they rejected it and they refused to sign for it, I guess would be irrelevant. But so send it both certified mail and regular mail, so you at least have an idea of when the date of delivery is. and the payment of the fine cannot be due 30 days less than that time period. So it's a big mess, really, the way that the legislature worded the statute. It's very confusing. It's extremely important to make sure you have detailed written fining procedures if you are going to be proposing fines and trying to adopt them in an HOA context. And then, even if you've done everything right, once again, and you have a fine that's $1,000 or more, we have one more layer of complication as it relates to a lien and collecting that fine. At least one court that we've gone in front of has said, I'm not going to foreclose a lien for non-payment of a fine. And we reasonably expect that to become a more prevailing concept with the judges, because they are elected officials and they do not want their names associated with foreclosing on a property for non-payment of a fine that's imposed by an HOA, especially when the clear intent of the legislature is to erode the rights of associations as it relates to imposing these fines. And we could see that in the way that the statutes are changing. So again, it is not an easy process to follow for HOAs. If you get everything right, it's still not necessarily going to be easy to collect that fine. So that leaves the question, is it a useful procedure? Is it something that's worth doing? Or are you better off just going through regular enforcement methods in order to enforce your governing documents? And the answer to that question is going to be very dependent on your own association and members. If you're following the fining procedures, you're getting it right, and your owners are complying because of it, that's great. But if you're like many HOAs out there, and condos as well, you're following the procedures, you're doing everything you're supposed to do, you're getting it all right, your committees are upholding the fines, yet you're not getting paid and the violations aren't being cured, then that's when other enforcement avenues are sometimes going to be more useful for you and more, what's the word, successful in application. So with that, actually, before I turn it back over to Adam, Shauna, do you know if we had any questions come in on fines that we want to touch right now, or do we want to just continue on?
Yeah, we just had one so far, and that was, well, we had two, but I think you answered the first one with the information. It was regarding time frame.
Okay.
The other one was they want to know if you can lien or fine in a co-op.
In a co-op, it is, I do not believe you can. I'm going to double check while Adam's talking just to be sure. The HOA statute specifically says you can lien. I don't believe that the cooperative 719 statute says that same thing. So let me just double check that to be sure. I don't want to speak out of turn and get that wrong. So let me check that while Adam's covering our next steps.
You can double check that. I think it mirrors the Condo Act.
I think so too. Yeah, that's why I said I'm pretty sure it's no, but I want to confirm that for you.
Oh,
So,
sorry. And then somebody said, are the rules the same for condos? So I think
As cooperatives, yes, yes, yep.
yeah, it's just the lien authority that the HOA has. So the HOA has a little bit more teeth, but it's the same general procedural process that Monique went through. And of course, that's a whole lot of red tape, and it takes a whole lot of time and usually effort on the part of the board or management to get a fining committee together if you don't have a standing committee, and to go through that whole process. And I'll tell you that more often than not, when a board goes down that road on their own, they'll hand us all the documentation and say we find them, and at least half the time we come across an error was done exactly right, and so all that time was spent and the fine can't be upheld. Or like Monique said, best case scenario, it's just $1,000 on their ledger, but the violation's ongoing, so you haven't really made it very far. We do have some communities that have success with fines and suspension of use rights. If it's working, keep doing it. Put a policy in place, have your attorney put together a written policy to guide you. Suspension of use rights is a tough one. One thing Monique didn't touch on is the enforcement of the suspension of use rights. We have clients who have gone down that road and they've said, well, we're going to keep them out of the pool. I'm like, well, does your pool have a key fob system?
Lock and gate,
If
exactly.
the answer is no, then, unless the board's going to get out there and lock arms and stand guard, there's not a whole lot you can do. And then we even had one community where they had a key fob, for the pool. They turned off this gentleman's key fob because they suspended his use rights to the pool. And he was hopping the fence with his buddies and he was still using the pool. And they said, what can we do? We've got to do something. And I said, all you can do is file a lawsuit. And they said, well, we called the sheriff and they told us the same thing. because it's a civil matter. So the enforcement of suspension of use rights is tough as well.
Actually, I want to say two things. First of all, confirmed, you cannot lien in a cooperative for a fine. So, and it does mirror the Condominium Act. So we're good on that. The suspension issue, Adam, we actually had this question just come up from one of our associations recently, and they said, well, can we suspend the use of cable and internet services because they're under a bulk agreement and they have, the ability to do it? And the answer to that from our perspective is no. But all three of the acts, Condo, Cooperative, and Homeowner Association Acts, state that you cannot suspend utility services. And there's argument as to whether or not internet and cable constitutes a utility as it has historically been defined, but the FCC has recently expanded their definition of utility to include internet and cable. And I think there's a good argument to be made that it falls under that category. Also, oftentimes people use their internet for communication services, and that would interrupt their ability to get emergency services and if the need arose. And there's even some legislative intent behind the statute when the word utility services was included to address emergency services, access to emergency services that may be required through the use of cable or internet. So for that reason, the answer from our office at least is no, you may not suspend cable and internet services for violations.
All right, so back to our timeline, back to our enforcement efforts here. We've sent the initial notice, the written notice with an opportunity to cure. The conduct is ongoing. We've either fined or suspended use rights, or we elected to forego that process for all the reasons Monique and I just talked about. But either way, we don't have compliance. It's time to escalate. How do we escalate? Well, there are two pre-suit requirements that apply to HOAs and or condos, and we'll go through those. And the first is pre-suit mediation. Now, a lot of people confuse mediation and arbitration, those two terms, and they're two very different processes in terms of both how they're overseen and the ultimate outcome and whether there's a decision maker. So let's start with the pre-suit mediation. We'll talk about what it is and then when it applies. Pre-suit mediation, that's where you have an impartial third party, that's the mediator, who goes back and forth between the parties and tries to facilitate a voluntary settlement agreement. So the mediator is not forcing anyone to do anything. The mediator does not have the power to force anybody to do anything. The mediator is not picking a winner and a loser. The mediator, again, is going back and forth and just trying to help the parties facilitate a settlement agreement. Two different kinds of mediation. Again, we'll talk about where it applies to HOAs, condos, and co-ops as a pre-suit mechanism. But often if you end up in litigation, you can expect to go to mediation again, because 99% of the time courts are going to require one more mediation before they'll allow a case to go to trial. The courts really want parties to settle disputes on their own, and so they require parties to take that one last stab at pulling that off. Again, it's both non-binding. The mediator can't force anybody to do anything. In some instances, we have clients where they've invited an owner to participate in mediation. We want to try to avoid a lawsuit. And we say, look, owner, let's get to mediation and have a mediator help us try to figure this out to avoid the expense of a lawsuit. And the owner simply refuses to participate in pre-suit mediation. They don't timely respond to the offer to mediate or otherwise decline to participate. Now, that owner in the pre-suit mediation context, they will have waived their right to recover legal fees in any ensuing litigation if they fail to participate in pre-suit litigation. But there's no way to force or compel a party to participate in mediation where they're otherwise unwilling to do so. And I make a note of that because sometimes our clients get frustrated with us and say, we don't want to go to court, we want to go to mediation. Help us mediate this and solve it. And resolve it short of a lawsuit. And you can't force another party, of course, to do that if they're not willing to. So the pre-suit mediation, again, the voluntary process. When does this apply? Well, it applies to HOAs under 720. So before you can file a lawsuit against an owner and or resident for a violation of your recorded covenants, you have to send a pre-suit offer to engage in mediation. It says, look, you have 20 days to respond to this offer. Pick a mediator from our list, and let's get a mediation scheduled. And if they agree to mediate, you have to go to mediation before you can file a lawsuit against that individual. to make an attempt to resolve the matter. Now, that used to be an HOA function only, the pre-suit mediation. That was only an option for HOAs. Within the last couple of years, maybe it's been 5 years or so now, that option has been extended to condos and co-ops. Condos and co-ops used to have to go through DBPR, Department of Business and Professional Regulation, arbitration, which we'll talk about in a minute. Again, condos and co-ops used to be required to go through that process before they could file a lawsuit. Then the legislature changed the statute to say, condos, co-ops, you can pick one. You can do the non-binding arbitration through the DBPR or send the offer to mediate. It's up to you. And for reasons we'll talk about here in a minute when we talk about arbitration, we generally steer our condo co-op clients towards pre-suit mediation rather than arbitration, with some limited exception. So let's talk about arbitration, and specifically Department of Business and Professional Regulation arbitration. So again, condos co-ops now have the option to go through that process if they so elect instead of pre-suit mediation. What's the difference between arbitration and mediation? Well, arbitration is more similar to an actual court hearing. It's very similar to a state court proceeding where the arbitrator will pick a winner and a loser. They're deciding your case in arbitration. So mediator has no authority to force anybody to do anything. It's just trying to help the parties come to a resolution. Arbitration, the arbitrator sits just like a judge. Sometimes there's a panel of arbitrators, and they'll make a decision. They'll pick a winner and a loser. You might have the ability to appeal that, essentially what is an appeal to the state court. In the DBPR context, you typically do. But again, there's a winner and a loser. You go through an abbreviated version of the litigation process. There's some form of discovery typically. So it's a more involved, almost like a court proceeding. And I mentioned that we typically steer our condo and co-op clients away from DBPR arbitration and instead do the mediation so that we can move on to litigation if there's no resolution at the mediation. And the reason for that is really twofold. The first, let's say we go into DBPR arbitration. We're dealing with this nuisance issue, and let's say we win. The arbitrator heard testimony from witnesses and says, absolutely, I'm going to enter an injunction, which is an order that tells this owner they have to cease and desist from the conduct at issue. Well, if the owner doesn't listen to the arbitrator and doesn't follow the order, the arbitrator, unlike a judge, has no ability to enforce that. The arbitrator doesn't have the ability to find an owner in contempt of court because we're not in court. So you win the case, but what do you really get if the owner doesn't comply? So you've spent all that money and gone through the whole process, and oftentimes you don't really obtain the relief that you sought, and you end up in state court anyway. The second reason is it's non-binding. Anybody can appeal it to state court, and you end up in state court anyway. So that ends up being an issue as well. Monique, you want to talk about maintaining evidence?
Absolutely. This is actually one of my favorite topics. And I think it's because I used to litigate so much. And, a lot of times our clients would come to us very upset, very frustrated about something that was going on. And we would say, okay, great, let's go through your evidence. And they didn't have anything. All they really had was, their own statements that this happened. And while that helps in court, it doesn't get us to the finish line. So what you do before we actually file suit is absolutely critical. First and foremost, written records of everything that happened. So if we're following our nuisance problem, let's say that the individual is showing up at board meetings, yelling and screaming and creating havoc to such an extent that it's very difficult for the board to conduct business. Well, let's have a motion to adjourn the meeting, get the meeting adjourned, reflect that in the meeting minutes, and then keep a separate note somewhere that this action was taken and this is why, and this is, what the individual, the owner, we'll just assume it's an owner, had done to create the nuisance there. Then let's say 2 weeks later, that particular owner gets into an altercation with another resident. They're threatening the other resident, throwing things in the common areas, and you have witnesses to that. Let's make sure that we have a written record of exactly what happened, who the witnesses were that saw the event take place, the date and time of the event, so that you have that in your records as well. Let's say that that individual went on to swing a bat and broke one of the mailboxes on the association property, and you have to have somebody come and fix that mailbox. Make sure you have a statement from the contractor saying that they came and they fixed the mailbox, and you hold on to that invoice for the repairs that were made, because that's going to form part of your damages. You should keep this written log going on a continual basis so that when you meet with your attorney and you go over all the various things that have occurred, even though you might have letters, demand letters from either the association's board or the managing agent or the attorney throughout the time period that these things are happening, you may be communicating with this owner, telling them to stop it. You want more than just those letters. You want to actually have the detailed log, because the witnesses to those events are going to be the people that will ultimately be providing testimony in court. Maintaining and preserving written communications, that's exactly what I was just talking about. As these things occur in real time, there's probably going to be communications to the owner telling them to cut it out, telling them to stop it. Maybe the board has taken action to communicate through email. Maybe management company has taken it a step further and actually issued a written demand letter. Maybe you have gotten counsel involved and one or two demand letters were sent by your counsel. Make sure you're preserving all of that evidence in a binder or electronic binder. I don't think anybody keeps paper records anymore, but make sure you at least have it electronically. That's your organized file. I like to recommend that you have a violation file for each and every unit if it's a condominium or property. Hopefully many of those will be empty, but however you're maintaining your official records, you should have an ongoing log of communications regarding violations for each individual unit or property, rather than just one folder for violations where you compile it for the entire community. Because especially if you're a big community, it can be very difficult to sort through that after the fact. And some of these things can go on for a year or two before it actually winds up becoming the foundation of a written complaint and litigation. So it can be difficult to keep track of that if you don't have a system for doing so. If you're with Castle Group, I know Castle Group has a good system for that, but not everybody has a management company. So if you are a board of directors that does not use management, you're self-managed, that is on you to make sure that you're keeping those detailed records. And last but not least, keep lawyer communications separate. When we say that, that means lawyer communications to you as a board, our attorney-client privileged communications. Those are privileged. Those can oftentimes relay our ideas or theories of a case. We can be telling you, well, there's a weakness here in your case because of X, Y, or Z. Maybe there's not enough evidence, or maybe we just think that it's not significant enough. Whatever those impressions are that we as your attorneys are giving you as counsel to the association, that is confidential. Our letters to the owners, however, are not confidential. So if we've written a demand letter to a particular owner telling them to stop the nuisance behavior that's occurring, that's not confidential, and it is an official record of the association, and it can and should be disclosed to other owners if they're requested in the course of an official records request. So when we say communications that we're keeping separate, those are our communications to you as the association. Adam, what am I missing on maintaining evidence before? Oh, actually, Adam, do you want to mention the new civil procedure rules where we have to make certain disclosures right out of the gate?
Yeah, so it's even more important than ever to have a process in place to compile documents and store documents in cases where it might end up in litigation, which is really starting from the beginning of any enforcement case, because and this is brand new as of January 1st of this year. There are new sweeping changes to the rules of civil procedure, which are the rules that govern the civil litigation process in Florida. And the new requirement is that the plaintiff in a case, the party filing the lawsuit, they have to submit documentation and information to the other side within 60 days of either filing the lawsuit or serving the lawsuit. And so no longer can we wait months into the case when the parties start exchanging written discovery. We'll talk about that more here in a minute. But you have to, on the front end, send over your evidence and the names and contact information of your witnesses to the extent that you've identified them and know who they are at that point within 60 days of filing the lawsuit. So the upfront work for the board, for the manager, and for the attorney is much greater than it was prior to January 1st of this year. You really need to make sure you have your ducks in a row as far as documentation goes and have everything organized, because of this new requirement in order to sustain your lawsuit and move forward based on the new requirement for these disclosures that have to go out. The other thing I'll add is the importance of a written complaint from an owner where you're dealing with a violation or an enforcement matter. So you have the nuisance conduct in this particular instance. It's somebody who's playing their music all night, and their neighbor, for good reason, you know, your neighbors, you have to face each other every day, says, I want to make an anonymous complaint, or, you know, I'm just making a phone call to the manager to let you know that this is happening, but I don't want to put it in writing. I don't want my name behind it. And unfortunately, that's as good as not making a complaint at all. And we've run into that a few times. If we don't have written documentation, if we don't have other residents that are willing to testify in court one day, if it comes to that, then you really have no basis to proceed. You have no way to win that lawsuit. You need the firsthand testimony of witnesses. So that's one we get quite often. It's the so-and-so called and said they were up all night due to loud music, et cetera, but you know, they don't want to put their name on it. Well, that's a problem. And so it sort of has to become a conversation where you say, help me help you. You know, we know you're going through this problem where there's this loud music at all hours of the night. You know, we need you to step up and be our witness, and we'll help you, you know, address the problem. But we've got to work together to do that. And I've had those one-on-one conversations with owners before. We don't, you know, typically communicate directly with owners in that fashion, but when we're leading up to a lawsuit, again, it's you help me, I'll help you, and it's a win-win, but we need you to step up and testify. And I completely understand why folks wouldn't want to do that, but it's necessary to prove the case.
Yeah, we should probably add that to the slide, Adam, so I don't forget it again.
Well, we covered it. We hit it.
That is an important, very important point.
Yeah. And we did have a question come in. Again, this is regarding a co-op. And honestly, it may really be a question for any, whether it's HOA or condo. Is lobby surveillance video considered official records of the association? And can the video be shared with all members, or is it only photos, like still photos, that are considered
Right, right.
records?
So do you want me to address that, Adam, or do you have it?
Nope, take it away.
Okay, so in the law, we used to say that video surveillance, digital media was, but not too many years ago, the statute was changed, all three of them. There's a catch-all provision in each of the official record statutes that says all other written documentation or written, you know, information of the association related to operations. The word written wasn't there previously. So we have since interpreted that to now exclude video and other types of digital media that's not in written form. So we don't believe that that is official record. However, you should have a camera policy that determines how you are going to maintain that video footage, how long you're going to maintain it for. And as it relates to litigation, Adam's going to touch on certain types of evidence, I believe, later. It still is something that may need to be produced in the course of litigation. So that's why your policies are very, very important. So there's that distinction between what's an official record and what's actually discoverable in the context of a lawsuit. Huge difference there, because the discoverable content in the context of a lawsuit is much more broad than what's considered official records. And your policy is what's going to protect you in the event that the information, the digital information, is disposed of prior to it being requested in the course of a lawsuit. So Adam, I don't know if you want to expand on that a little bit further, or if it's part of your topic and that you're going to hit later.
Yeah, let's hit it with discovery.
Okay, that's what I figured.
Okay. All right, so now we've got the initial notice, the opportunity to cure. No compliance, we still have the nuisance behavior. We've gone through finding or suspension of use rights or decided, hey, it's not worth our time, and we've bypassed that step. We've done the pre-suit mediation or maybe the pre-suit arbitration to no avail. We just haven't been able to obtain the relief that we want pre-suit. Well, this is the point where the board's back is up against the wall, so to speak. The owner simply will not comply. They won't knock off the nuisance behavior, the harassment, whatever it is. And your legal counsel will come to you and say, look, there's only one enforcement avenue that's still available. And it's an expensive one. It's a time-consuming one. It's a road that nobody wants to go down, but it's the last option. And again, we get back to that fiduciary duty to uphold your governing documents. And so if an owner simply will not comply and you reach this stage and exhausted all other options, then litigation is the next option. And litigation generally takes two forms. We're either in state court, a Florida state court, or we're in federal court. 99% of the time, a community association, whether HOA, condo, or co-op, is going to be in state court when we're talking about enforcing your governing restrictions. The rare instance where we may be in federal court is if there's a Fair Debt Collections Practices Act violation, something to do with the collections of assessments, maybe an owner's proceeding with a claim in federal court under that federal law. We also see emotional support animal issues and fair housing violations in federal court. So those are the two big federal laws that may drag associations into federal court. But again, generally, we're filing these things in state court. Once we're in state court, there's a couple of common motions that are filed with some regularity. And I think the terms are often thrown around and there's a discussion with the board. Hey, in this particular case where the owner's not paying their assessments, or in this nuisance case, we're going to look to file a motion for temporary injunction and a motion for summary judgment. And sometimes board members will speak up and ask and say, well, what is that and what does that mean? And sometimes not. And I get off the video call and think, I wonder if they just nodded and they kind of knew what I was talking about. So we'll go over exactly what those motions are. Again, these are the more frequently filed motions or motions that the board should be aware of when they think about a lawsuit to try to secure enforcement. And the first is the motion for temporary injunction. So an injunction, again, is a court order requiring someone to do something or to stop doing something. So when we're seeking a temporary injunction in our nuisance case, we're going to the court and asking the court to order this individual to knock off the nuisance conduct. It is basically a cease and desist order. Let's say the nuisance violation, we have a hoarder. We have somebody who won't clean up their unit. We've had this happen. Rotten food. I mean, some pretty disgusting examples. And so in this case, we'd go in front of the judge and say, we want a temporary injunction that says they have to clean up their unit. In the case I'm referring to, it was they have to clean up their unit and hire a pest control company and hire a cleaning service. Judge, we want them to fix up their unit. It's a condo, there's shared walls, and it affects everybody. And the temporary injunction is an important tool because we can go in front of the judge and say, Judge, we can't wait for a trial before you help us resolve this issue. It is so serious and the conduct is so egregious that it can't be a year from now following a trial where you enter this injunction. We need you to enter an injunction now, early in the case, that says the owner has to take some action to address the issue before we ever get to trial. So if they're harassing the board and management, it'd be judge. We need an order that says they have to knock it off while the lawsuit is pending. Then at the trial, the court can enter a permanent injunction, cease and desist order that carries on after the case. But again, this is, Judge, during the course of the lawsuit, we need your help. And when you file a motion for temporary injunction, you have to schedule an evidentiary hearing. You'll go to court and present witness testimony. It's like an abbreviated trial. And it's a high burden for the association to win there because you haven't gone through discovery and all of that. But the judges will award that in the context of a covenant violation if it's a serious harassment issue. If it's a nuisance issue where if it takes more time to address it, mold might spread into the other units. The courts will step up and enter a temporary injunction. Let's contrast that with a motion for summary judgment. Now, a motion for summary judgment is a dispositive motion, which means it ends the case if you're successful. And a motion for summary judgment is where you can go in front of the judge and say, Judge, we don't need a trial in this case. You don't need to hear from witnesses. You don't need live testimony. You don't need us to present evidence at a formal trial because there are no factual issues in dispute here. Everybody generally agrees on the facts, or we've at least proven the material facts, and they're not rebuttable by the other side. And so it's just an issue of law, Judge. And so we want an order without the expense of going all the way to a trial. And you'll probably hear that motion in the context of an assessment case, a past due assessment case, collections foreclosure, because often the only defense to non-payment of assessments is payment of assessments. There's no other. We have owners that'll say, well, the association hasn't maintained the common elements, so I don't have to pay my assessments. Well, that's not a viable defense. So in a foreclosure action, it's usually pretty cut and dry, and we can get in front of the judge and say, Judge, either they paid or they didn't. You don't need a trial to hear all that. A motion for summary judgment is appropriate. If the court agrees, they'll enter a final order right there and then, and the case is over. We've avoided the trial. We've avoided the time it takes to go to trial. We've avoided the expense of a trial. So we're always filing litigation with an eye towards trying to resolve it early on summary judgment and to keep fees lower. Finally, we have the motion for contempt, motion for writ of bodily attachment. So where this comes up the most for us is at the end of a case, right? So we have the nuisance conduct. We've gone to court. We obtained a temporary injunction, and the individual just won't comply. They haven't cleaned up their unit in the hoarding situation, or they keep playing the loud music, or they keep harassing the board and management. We can go back to the court and ask the court to find them in contempt. And if the conduct is egregious enough, the courts will do that. They'll find them in contempt of court. It's civil contempt. And basically, it's their final warning, comply with the court's order, or there will be significant consequences. And the consequences are found after we file the motion for writ of bodily attachment, because what a writ of bodily attachment is, it's basically the civil equivalent of an arrest warrant. The civil judge will enter an order that says, I've entered orders multiple times telling you, owner, to do something, to stop this conduct, to clean up your unit. You've disregarded the court's orders, and now you're going to spend some time in county jail. And so that hopefully when you get out, you'll realize this is serious and you need to address it. And I think oftentimes there's some shock, particularly when we're dealing with like a dog violation, or we had one case where an owner refused to paint their house despite they lost the lawsuit. They were ordered to do so. They just wouldn't paint their house, repaint it. And the house was dilapidated and needed painting. And the court gave them a couple opportunities. And finally, the judge said, look, you're going to spend 3 days in Pinellas County Jail. And that individual spent 3 days in Pinellas County Jail. And they got out. And they still didn't paint their house. And then they spent 3 weeks in Pinellas County Jail. I think the judge let him out after, 15 or 16 days or something, when he promised he would paint the house. And then finally he painted the house. But it becomes that serious even over something like a house that hasn't been painted, because if the courts can't uphold their own orders, if they don't have the authority or the ability to enforce their own rulings, well, then the whole judicial system crashes. So even though it's something that may seem like it wouldn't get that far, we're talking about painting a house, the court has to uphold their own orders. And by the way, this is the authority that the court has that the arbitrator does not. So if an owner is ordered to paint their house by an arbitrator in arbitration and they don't do it, there's nothing we can do. There's nothing the arbitrator can do other than going to state court and talking to a judge. But the judge has contempt power. The judge can enter a motion for writ of bodily attachment. And we've been able to secure relief in that fashion, where the owner won't comply with the judge's orders, either temporary injunction, summary judgment, or we've won at trial. Written discovery. All right, so we filed some motions. We've done some motion practice in the litigation. Discovery is the process whereby the parties exchange their evidence in the case and what they plan to present to the court. There's common written discovery. That's a request for production of documents, is a name you'll see pretty often. That's where the other side can send you a request for various documentation that relates to the lawsuit, and you have to turn over all that documentation. And of course, it's a two-way street. We can send the same thing to the other side, and they'll turn over their documentation that's relevant to the lawsuit. But I put this is the most dreaded part of litigation for boards and managers, because it's not a fun process. They have a pretty wide scope of what they're allowed to request. And so it can be a pain to go through this documentation. It goes back to what Monique talked about in trying to compile all that earlier. It'll be a little easier now because of the disclosure requirements. You'll have already turned over a lot of the relevant information, but discovery is a tough part, I think, for managers in particular, who are often tasked by the board to go through all of the documentation. That's why it's important to have it, again, compiled and organized up front, because they can ask for a lot of documentation. A written request for interrogatories. Interrogatories are when they send questions that you have to answer under oath. Again, we can send them, the other side will send them. And again, a list of questions that you have to answer in writing and submit to the other side. There's the request for admissions. That's where they say, admit that, or we'll send it to the other side, admit that there are bowls of rotting food in your condo, or admit that you failed to retain a cleaning service despite the court's order. Something to that effect. And the other side, it's a one-word answer. They either admit or deny what we've put in front of them. And then all of that documentation, all of those written responses that we receive, all of the admissions that we receive, that's what we take with us to trial as we build our case. And the other side does the same thing. So that's the written discovery. The other part of discovery, and this is easily the most dreaded part of discovery, I think, across the board, are depositions. And that's where both sides can take live testimony of potential witnesses in a case. You sit down with a court reporter. A lot of it's over Zoom these days, so that's a little more palatable for board members and managers. But the other side asks you questions and takes your deposition, listens to your testimony just as they would in court. It's a little more informal, but you are under oath just like you would be in court. And of course, board members and managers try to avoid it. We try to get you out of it anytime that we can. But there is a lot of leeway for parties to conduct a deposition of individuals who they think might have information relating to a case. So oftentimes it's very hard to protect, if you will, board members and managers where a deposition's been requested or where you've been subpoenaed. So we always have meetings with our board members ahead of time, with our managers ahead of time, to talk about how the depositions work, what questions you might be asked, and give you some other tips and pointers to hopefully calm your nerves. But again, it's difficult to completely have a mechanism to go in front of the court and say, keep the board out of it. They're volunteers. The board will the court will typically require that those depositions take place. The cost of litigation. Monique, you want to take that one?
There we go. Absolutely. So cost of litigation, a lot. Can we leave it at that, or I'll expand on it?
You covered it.
There's a number of factors that really go into what litigation is going to cost. And, experienced litigation counsel should give you an overview of expectations before you even file a complaint. Of course, your counsel is going to be filing the complaint, but before you give the green light for your counsel to file the complaint, you should have an open and frank discussion with your counsel about it, and hopefully, if possible, get something in writing from them. So at least you can set some expectations. But the problem is there's really no way to accurately predict what any type of lawsuit is going to ultimately cost because of the various factors involved. Some of those factors include the venue, and there's arbitration, which is going to be less expensive. But as Adam said, there's no enforcement mechanism for arbitration. So it might cost you twice as much if you have to get an enforceable order in court anyways. The venue could be in circuit court or county court. County court's typically going to be a little bit less expensive because the cases move faster in county court generally. Circuit court, there's usually a higher amount in dispute, or there's a certain issue that triggers the jurisdiction of the circuit court. Those cases can be a little bit more expensive. And then federal court, let's say that the issue involves discrimination. To use our nuisance example, perhaps we've sent some demand letters to this particular individual, and they've said that you are discriminating against them based on a disability, and therefore we wind up litigating in federal court because the Fair Housing Act that protects individuals with disabilities is a federal law. So federal cases tend to be the most expensive cases because of various rules of filing and pleadings and memorandums of law that are required to be submitted with every single thing that's filed in a federal court. So the venue is going to be one of the factors that's going to influence the cost. Another one is the nature of the dispute. Generally speaking, foreclosure actions, that is litigation, those tend to be on the lower side because, as Adam said, there's not many defenses to a foreclosure action other than payment of assessments. Our nuisance example, that could be a little bit more expensive because there are going to be factual issues in dispute. It's going to be very hard to get a nuisance case to summary judgment, as Adam was talking about before, because what constitutes a nuisance is often a subjective decision. Construction cases that are going to involve expert testimony, those can be much more expensive because now we're involving experts, things that your counsel can't testify to. If you have a condominium and there's termite damage in the condominium, you're going to have a separate expert testify as to the extent of the termite damage, how bad it is, what needs to be done. So it really is going to depend on the nature of the dispute as well. The number of parties to the action, I think that's pretty obvious. If you have the association and a single owner disputing the issue, that's going to be less expensive, but there are times where there can be multiple parties to an action. Construction cases, for example, you could have subcontractors involved. That could certainly increase the cost of litigation. Summary judgment, I briefly mentioned that actually already. If there's no issue in dispute and we can resolve the case in summary judgment, fortunately, that's going to drive the case down or drive the cost down. Trials are very, very expensive, and you'll often notice that there's 2 times during the course of litigation where your costs are going to spike. Those are going to be the highest months. That's going to be during the period of discovery, when depositions are being taken, when evidence is being exchanged, and then the time where we're actually preparing to go to trial, in the weeks leading up to that trial, and of course the trial itself. That's a very expensive time, as often your attorneys are going to spend 8 hours a day plus getting ready, pulling all the evidence together, preparing exhibits, making sure that they understand every single detail, going over testimony with experts and with all the witnesses. So the way that the matter is resolved is going to influence the case. And then last but not least, it's going to depend on the other side. How is the case being defended? Is there an attorney involved? And you might think, well, if there's an attorney involved on the other side, certainly that's going to make it more expensive. Not necessarily. Sometimes we have very reasonable attorneys on the other side of the case that, like our office, are interested in resolving the matter as efficiently as possible. But unfortunately, not everybody is like that. And, opposing counsel can be one that just wants to drive the cost of litigation through the roof. And there are delay tactics and other things that they can do that can make a case much more expensive. That often takes place, again, in the areas that we said, in the discovery and pretrial motion practices. Sometimes if the owner is defending the case himself or herself, that can make it very, very difficult as well, because courts tend to be a little bit more lenient with owners that are handling their own cases. They give them multiple options to, try to file things, and we still have to respond to those. So that can make the case very expensive as well. So for all of those reasons, it is really difficult for us to predict what the cost of litigation is going to be at the onset, but certainly we at least have an idea, and we'll hopefully be able to give our clients some guidance going into it as what they can reasonably expect. Adam, are you going to cover how those legal fees may be recovered?
Yep, that'll be next.
All right.
Yeah, like Monique said, we typically try to prepare an outline of the litigation costs pre-suit, where we'll sort of break it out by, here's the pre-suit drafting of complaint projected expenses, here's the motion practice expenses, here's discovery expenses, pre-trial and trial, and give you a general time period for, okay, this will probably be the first 2 to 3 months of the case, so that boards can try to budget to the best of their ability, and that we can try to give you some direction there. It's usually a broad range and pretty heavily caveated. We at least make an effort to try to put that together. So again, boards can budget within some degree of reasonableness, and we can help you out there.
Adam, when you go on to recovering legal fees, and I apologize because you might have already covered this and I might have zoned out and missed it, I'm not sure. But on the pre-suit mediation statutes, did you already cover how it works to shift the potential liability for attorney's fees if they don't respond to an offer to mediate?
Yeah, we covered that under the pre-mediation. And so
I
again,
thought you usually do, but I just want to make sure.
yeah, I'll hit that again. And with the recovering of the legal fees, because that is an important point, and it gives the association a lot of leverage. And Monique mentioned that, it's not always the case where the attorney is aggressively defending on the other side that is the most expensive case. And I think the most expensive enforcement case I've had in the last decade plus was one where it was a nuisance case, and the guy was a nuisance. And he wasn't just a nuisance in the condominium community, he was a nuisance to the court. And he filed something new every week. He was an armchair lawyer who would find something on Google and, come just close enough to a legitimate motion or argument that I would have to respond. And so he's filing this thing every week, and I've at least got to file something objecting to it until I can get in front of the judge and say, hey, judge, how about we, curb his ability to file something every week? And so I think that was the most expensive case we had. And again, it was a nuisance case. So often the nuisance conduct lends itself to a tough litigant more often than not. In that sense, they tend to be the more entitled of the bunch.
Right.
All right, so recovering legal fees, and I apologize to our co-op attendees. I left out 719, but you can include that here in the first bullet point. So the prevailing party under 718, 719, and 720, they provide, all of those acts provide that the prevailing party to litigation falling under that act, which would be enforcement of your governing documents, the prevailing party is entitled to recover their reasonable fees and costs. We'll get to the actual ability to cover that in a minute. So again, 718, 719, 720, you have the ability to recover legal fees as a matter of statute. If there's no statute or contract on point in the state of Florida, then you have no right to recover your legal fees. So keep that in mind for lawsuits where we step outside of the enforcement of covenants world. If we're in a construction dispute, you're in a dispute with your vendor, your landscaping vendor or something along those lines, there's no statute that's likely to be on point that provides for prevailing party attorney's fees. So that's where you have to look to the contract and say, okay, does the contract say that if there's a dispute that arises in connection with this contract, that the prevailing party is entitled to their fees and costs? Because again, if that's not as a matter of statute and it's not in your contract, then you have no right to recover fees. And that's a huge factor in your decision on whether or not to file a lawsuit. An important note with contracts, we'll often see, particularly in construction contracts, if they're not sent to legal counsel ahead of time, primarily, because I think most counsel, certainly our office, is going to edit this provision. But we'll see a lot of contracts that say, if the contractor has to sue the association and the contractor wins, they're entitled to their prevailing party fees and costs. But it says nothing about if the association prevails, whether they're entitled to their fees and costs. Under Florida law, it's a two-way street. Whether the contract says it's a two-way street or not, it's generally going to be a two-way street in that provision. But what we've seen in a lot of construction contracts is the contractor getting a little more clever, and they'll change the provision to say, if we win in a lawsuit to recover funds that are unpaid under the contract, we're the prevailing party and entitled to fees. Okay, so it's a two-way street, but only in connection with the failure of the association to pay the contractor. If you, the association, sue for construction defects, that provision doesn't cover construction defects. So they've sort of found a way to weasel into a one-sided fee agreement there. So I guess the takeaway there is have your legal counsel look at your construction contracts, your vendor contracts, to make sure you're protected, because so often, and we'll talk about this more in a minute, but these lawsuits come down to, in a contract, breach of contract case, is the cost of legal fees worth the damages that I might recover in this lawsuit? It's a business decision. And typically that decision's a little easier if you have the right to recover your fees should you prevail. So you want that in your contracts. Final note on recovering fees, whether we're under a contract, whether we're talking about the nuisance violation and the owner. If we win the case, we get our injunctive relief or we get damages on the breach of contract case, and then the court awards our legal fees, it's important to note that all you get really is a shiny piece of paper that says you're entitled to money. And you can put that piece of paper on your refrigerator. But what the piece of paper does not say, importantly, is that the other side has to pay you that money. And so it's sort of a weird distinction. You're entitled to it, meaning you're entitled to collect on it. You're entitled to chase down that money, I would say. The other side is not being ordered to pay you that money. And so what that means is you get the shiny piece of paper that says you're entitled to money. Now it's your job to go seek recovery of that money. You have to go search for assets to see if they have anything that could satisfy the judgment, bank accounts, boats, cars. Can you garnish their wages? It's the onus is on the individual or the entity that obtains the judgment to pursue recovery of that. And a big issue there is legal fees incurred to pursue recovery under the judgment generally are not prevailing party attorney's fees. So those are sunk costs. So you have to make a business decision on whether to pursue that. And I see it's 12:04, so I'll move along quickly here. Is filing suit worth it? Well, the first bullet point we've hit quite a few times. I won't beat a dead horse, but do you have another option? Are you upholding your fiduciary duty to enforce the governing documents? If it's a covenant violation, most of the time you have an obligation to file that lawsuit. There's not much of a question there. But when we're talking about a breach of contract case, a vendor dispute, it's, well, what's the cost of the lawsuit going to be? What are we going to have to pay an expert? What are our projected legal fees? And weigh that against what you're likely to recover in the case. What's your best day in court? What's your most likely day in court? That's a conversation you have to have with your lawyer and then make a business decision. And there's a lot of cases where somebody will come to me and say, well, we have a warranty claim. They won't honor the warranty. The damages to the roof are $30,000. Help us recover. And I say, well, I can help you recover and we can go to court, but it's going to be $60,000 in court. So I'd rather see you pay 30 just to fix it rather than pay me 60 to fight it. So there's that business decision that has to be made in consultation with your legal counsel. Other pre-suit requirements to be aware of. We talked about mediation and arbitration as pre-suit requirements in the covenant enforcement case, the violation case, the harassment case, but other ones to be aware of outside of that context. Your governing documents or your contract may require arbitration before the American Arbitration Association. That's where you pay the arbitrator an hourly rate to preside over the case. Sometimes it can be a panel of 3 arbitrators in a construction case. So very, very expensive. Get that out of your declaration if that requirement's in your declaration. Make sure you look at your contracts. What pre-suit dispute resolution mechanisms do you have to go through before you can file a lawsuit? Do you have to get an initial opinion from the engineer on the project on whether, who's right and wrong if a dispute arises? Do you have to mediate? Do you have to go through arbitration under the contract? Florida's Chapter 558 is Florida's construction defect statute. If you have a construction issue with a contractor, there's a whole timeline that you have to follow. You have to give an initial notice. The other side has an opportunity to inspect the alleged defects. And then there's some exchange or attempt to facilitate a resolution. It's sort of an even more informal mediation process that you should be aware of, but it takes some time. So you need to be aware of it if you're having construction issues. And then whether your documents or the statutes require membership approval. We'll see that in a lot of governing documents. Chapter 720 for HOAs requires it, where the amount in controversy is over $100,000. So be aware of that. Have your counsel look at that before you agree to file a lawsuit. Last thing you want to do is get kicked out for not having membership approval, or have an owner challenge the fact that you filed without the appropriate approvals. How to avoid litigation. And we see this all the time. We'll have new boards come to us and say the prior board didn't enforce. Everybody thinks they can get away with whatever they want, or nobody's following this one particular rule. What do we do to address it? Well, once you take one owner to task, or once you take one resident to task and show them that you're willing to fine, or you're willing to go to arbitration, mediation, and ultimately willing to file a lawsuit, what we've seen time and time again is that the rest of the owners will fall in line. They'll go, the board is serious about this. We need to fall into line, or we're going to get sued just like Bill did down the street. And so they generally at that point will fall into line. You might have to see it through with one owner, but that tends to solve the problem. Have your attorney review contracts before you sign contracts in general to make sure that there's appropriate fee provisions, to make sure you're protected across the board on timeliness of payments, payment schedules. In construction contracts, there's the construction lien law, and that means any contract over $2,500, the association is subject to a lien on their property by the contractor, any subcontractors, and any material suppliers if there's non-payment. And it's not just if the association doesn't pay, but if the contractor doesn't pay the subcontractor may be able to lien the association's property. So you really want to make sure those construction contracts are buttoned up and that your counsel reviews those. Developer disputes, start the process early. Statute of limitations period is limited. So if there's anybody facing turnover, you want to get the ball rolling, get with legal counsel, start vetting engineers, and make sure you have an attorney that is willing to take a case to trial. If they're going to file a lawsuit, sometimes you have settlement lawyers who go, I'm going to file this lawsuit and it's going to settle, and I have no intention of going to trial because I've never done a trial or hate trial, and I'm going to do everything I can to get it settled. And that kind of goes to the first bullet point. You might have to take one owner to task. You might have to go to litigation, particularly in a construction case. You want to make sure your counsel's prepared to take your case all the way, or don't file it. If the board's not, have another conversation about other ways to address a problem. But once you file a lawsuit, everybody involved has to be prepared to go to trial. All right, and that does it. Let's see, stop sharing, I believe.
Perfect.
All right, did we get any other new questions?
We did not. No, we had somebody say, thanks, this was an awesome webinar. So thank you. And And so, yeah, guys, no, this was great. Not a lot of questions. So obviously you guys did a good job.
Either it was very boring
I
or
was gonna say
we
either that or
covered
they're
it all.
all
I'd like to
sleeping.
think we covered it all.
I think you covered it all. I will go in that direction for sure.
Thank you.
No, I think this is a good one, because we do from time to time we talk about, fining and covenants enforcement, things like that, but we don't really get in this deep into, where you can go with it and
Mhm.
pros and cons, and all of that. So I think this was very informative. It was great. So we appreciate you guys joining us today and sharing your knowledge.
Well, thank you, Shauna. Thank you, Castle. And thanks everybody who joined us here this morning and into the afternoon. Sorry we ran a little over, but we
It's okay.
appreciate you joining us.
Yeah, absolutely. And like I said, we'll share the content and Monique and the firm's information here for you guys for the end of the week, by the end of the week, I should say. So you'll have all of the information if you want to reach out to them and the presentation that they gave today. So thank you, everybody. Enjoy the rest of the week, and we'll see you all soon.
Thanks,
Thank you all.
everybody. Thanks,
Bye.
Shauna. Take care.